A recent judgment of the Himachal Pradesh High Court held that lack of injury marks on the body of a rape survivor does not disprove that rape took place. The High Court said that absence of injury on the body of the accused, or for that matter, prosecutrix, would not render her version in any manner to be false or doubtful. Exact location of the angle in which she was subjected to intercourse cannot be left to the imagination of the doctor, in whose view there ought to have been some marks on the buttocks of the prosecutrix. After all, there were injury marks on the face of the prosecutrix, which she has stated to be on account of gagging of her mouth. The rape victim survivor was a young village girl, a student of class 10th, who had gone out to the fields at night to relieve herself when she was attacked by the accused and raped. Her aunt, who came out at that time, witnessed the incident and called other women to the spot. Upon arrival of the women, the accused fled. The rape survivor's testimony, along with the testimony of the witnesses plus the other evidence, were anyway sufficient to convict the accused. The accused put up an argument that the complaint was filed with the police after one full day. The court, however, found that the delay occurred because the head of the family was away at that time. It observed that in rural areas, generally people are reluctant to report the matter till the arrival of the head of the family. Thus, there is no delay in lodging the FIR. With criminals jumping ship to escape the long arm of the law at home, the 1969 Supreme Court ruling in state of West Bengal versus Jugal Kishore More gains importance. In this case, the accused Jugal Kishore More was convicted for criminal conspiracy in foreign exchange violation. The accused had an address in Hong Kong where he fled to after committing the offence. He was later extradited from Hong Kong for trial. However, he challenged his extradition on the basis that it was without authority in the absence of a notified order under Section 3 of the Extradition Act 1962, which could have added Hong Kong to the list of countries to which the act was applicable. The Calcutta High Court had quashed the extradition. However, the verdict was overruled by the Supreme Court, which stated, "But that did not, in our judgment, operate as a bar to the requisition made by the Ministry of External Affairs, Government of India, if they were able to persuade the Colonial Secretary Hong Kong to deliver More for trial in the country. If the Colonial Secretary of Hong Kong was willing to hand over More for trial in this country, it cannot be said that the warrant issued by the Chief Presidency Magistrate for the arrest of More, with the aid of which requisition for securing his presence from Hong Kong was to be made, was illegal." The court observed that extradition is founded on the broad principle that it is in the interest of civilized communities that crimes should not go unpunished, and on that account it is recognized as a part of the Committee of Nations that one state should ordinarily afford to another state assistance towards bringing offenders to justice.